what is the difference in the visit visa process in Canada and in the US. The US visa process is comparatively simpler. It's more arbitrary. There is no right of appeal available. You fill out a form DS-160 and you take an interview date. Before the immigration officer, when you are appearing in the interview, he can ask you a couple of questions or more and then take a decision there. He may be able to see your documents, he may refuse to see any documents you take there. Compared to that, the Canadian temporary resident visa process or visitor or study permit or work permit process is highly formal. You have the right to take the decision, if it is a negative decision, to the Federal Court of Canada as well. Here, you are not interviewed most of the times. You are able to provide as much documentation as possible during the application process. You can engage an attorney, a lawyer, who will complete your application on your behalf and submit all the forms, all the supporting documents, and all the arguments or submissions to the visa officer. The visa officer is obliged to look at all that documentation and then take a decision. If there's a negative decision, the visa officer's decision could be challenged before the Federal Court of Canada, where a judge will look at the arguments of both the sides, and if the visa officer was unreasonable or incorrectly applied the law, the judge could remand the decision back to the visa office again, where it'll be looked at upon once again for a new determination. This is Sajjad Malik, a Canadian immigration lawyer, speaking to you from my office in Oakville, Ontario.